You probably didn't hear about this yet, but a California court just weighed in on the complicated topic of how college campuses handle sexual assault cases. On Tuesday, California's 2nd District Appeals Court held that due process was violated in the case of John Doe versus USC. What does that mean? In this case, it means the court said that Doe wasn't given enough information about what he was being charged with, and his opportunity to defend himself wasn't fair. Here's the breakdown of what happened the night this all started, according to court documents. The students involved were not identified, so I'll call them by John and Jane. On a night in January 2013, John, Jane, and one other student had consensual sex at a party. But later that night, Jane was performing consensual oral sex on John when at least one person joined in the sexual activity. Jane later said the other men got rough and someone other than John smacked Jane on the butt hard twice. Jane started crying, John pointed out that Jane was crying, and sexual activity stopped. John and Jane were both USC student athletes at this time, and both had been drinking that night. None of the other people involved attended USC. Jane's coach noticed a lack in her confidence and recommended Jane see a counselor. That counselor asked Jane if she's ever been sexually assaulted, and Jane said that's when it clicked for her. Jane filed a sexual assault report with USC in August. The university began an investigation. After an investigator spoke to Jane, USC sent a letter to John telling him he had allegedly violated 11 items in the Student Code of Conduct. The letter included a date and an approximate location. But John's lawyer says what he didn't get throughout the process was factual information about the incident that led to the alleged violations. USC's disciplinary body, SJAX, found John Doe responsible for 9 violations of the Student Code of Conduct, but on appeal, that was reduced to 2, both related to the actions of the other people in the room. John Doe was suspended for 2 years. Was that fair? John didn't think so, and he sued. And he lost, at first, but on appeal, the appellate court said that John Doe didn't get enough notice of the facts being used in the charges against him, so he couldn't defend himself, and that's not fair. I talked to John's attorney, Mark Harris, who said that while John is gratified at the win on appeal, his educational and career interests have been irreversibly affected. Harris didn't comment further to maintain John's anonymity. I reached out to USC's Title IX office, and they referred me to attorney Ted Boutros, an appeals specialist, who couldn't be reached for comment. But Boutros told another publication that USC's process is fair, consistent with federal law, and protects the rights of all students. Harris says, as far as he knows, no notice of appeal has been filed in this case yet. But if USC does successfully appeal that decision to the Supreme Court of California and loses, every school in California will be held to this standard. Regardless of whether that happens, this case has the potential to become a benchmark for what rises to the level of due process in college campus sexual assault cases. What's also interesting here is that Jane and John were both drinking that night. So under California's 2014 Yes Means Yes law, USC would have been able to pursue a theory of no consent by intoxication against John when Jane filed. But that didn't happen here. And it's not clear that they could retroactively apply that standard now to a 2013 event. Schools have been saying for a long time that they don't have the resources to treat sexual assault cases like criminal trials. So is it even appropriate for them to try and handle them at all? What do you think about all of this? Let me know in the comments. This has been The Law of Attraction with Stephanie Haney. Thanks for watching.